My name is Jim Conaway, and this video presentation is being completed for William Woods University EDU sports law class. This particular case study that I have chosen for week 4-1 graded assignment is Boston Athletic Association versus Sullivan. The facts, well, to begin with, this case interested me because I've always been fascinated with the Boston Marathon as an event, and that's more than anything is what caught my eye. I was amazed at the amount of court cases that went back and forth with regard to this particular case, and as it turned out, this case wound up serving as a landmark case that gave broad protection to the proprietors of different well-known sporting events. As far as the facts of this case are concerned, the Boston Athletic Association has been sponsoring the 26-mile, 385-yard Boston Marathon foot race since 1897. In 1983, the BAA began a campaign to market its name via licensing agreements, and it registered the names Boston Marathon and BAA Marathon in Massachusetts in 1983. The registered name, Boston Marathon, was submitted to the United States Patent and Trademark Office in 1985. Meanwhile, the defendants of this case, Bo Teese Incorporated and Mark Sullivan, were interested in merchandising products referring to the Boston Marathon. Sullivan retails wearing apparel in nearby Hopkinton, Massachusetts. Meanwhile, in 1978, Bo Teese began to imprint and Sullivan began to sell shirts bearing the Boston Marathon name. In 1984, the BAA had agreement with Bo Teese to sell the BAA shirts to give away to its athletes. In 1986, Image Impact became the BAA's exclusive licensee. In the meantime, Bo Teese and Sullivan ignored the warning and request of the BAA to stop selling the t-shirts at the site of the event and when the event was being conducted. This in turn started a number of court hearings that resulted from both sides. As far as the arguments for both sides, in a simplistic way of looking at it, the Boston Athletic Association felt it had exclusive rights to sell the t-shirts at the site, and that the defendants did not, while the defendants in turn felt that they could sell souvenir products when they chose, because they began selling them as early as 1978. In the first court case, and like I said, there were a series of about 4 different court hearings. The court denied an injunction to the Boston Athletic Association to keep Teese and Sullivan from selling products. Then likewise, another hearing was held, and it was appealed, where the appeal was denied. In turn, in 1987, both Teese and Sullivan were gearing for more t-shirt sales, and at this time the Boston Athletic Association went through district court again, and their injunction was once again denied. Finally, after the fourth round of court hearings, the appeals court of the first district finally ruled in favor of the Boston Athletic Association, and said that whether or not the Boston Athletic, since the Boston Athletic Association was the one that was doing the legwork with the event, that they were entitled to sell the official souvenirs, irregardless of the controversy regarding which whether the general public was to get mixed up with what event was the official souvenir shirt from the vendor of the event or from another vendor. The implications of this event for the activities and athletic administrator are that it really shows that working to obtain a mutual understanding or a mutual working agreement is really in the better interest of all parties concerned. It's far easier than a number of court cases, court hearings, and much more simplistic to resolve. I know from my own experiences as an athletic activities administrator, it was always a lot easier to respect the wishes of either the sanctioning body or whoever was in charge of the event than to try to do something on my own. And I know that controlling the sales of merchandise with an event like the Boston Marathon, it's spread out over 26 miles. This would be an indeed hard to police type event and would not be easy by any stretch of the imagination. But in the long run, it's just better if all parties can work out some sort of working agreement to where one respects the other and the dispute is resolved without having to go back and forth to court.